I'm Susan Wheeler. I'm the University Counsel and Special Assistant Attorney General. I work at James Madison University in Harrisonburg, Virginia. Been there about 15 years and worked before that at the University of Houston system and in the General Counsel's office. So I've been practicing for about 28 years in higher ed. A question for the audience as we get started. How many of you have a lawyer on your campus that you can ask questions of? Oh, thank goodness. If you don't have a lawyer on your campus, how about an outside law firm that you can call? Excellent. You have them on speed dial? Just curious? Okay. I am, obviously, not your lawyer. You know who your lawyers are, and that's wonderful that you know who your lawyers are. If you listen to me today, that's very gratifying for me, but it really doesn't help you that much. What you really need to do is ask these questions of either your in-house lawyer or your outside lawyer who represents your institution, because rather than just giving that person gratification, you actually give yourself protection. If you listen to what your lawyer advises you to do, then you get what's called a good faith defense if anybody ever comes knocking at your door, like the EEOC or the OCR or the DOJ or any of those wonderful alphabet soup agencies that we all deal with. Another thing I need to say is, and this is one of those sort of things that lawyers do all the time, these are my views that I'm going to be giving you today. These are not the views of James Madison University. They're not the view of the Virginia Attorney General's office. This is just me. It's just you and me. That's what we got going here. If anybody had an opportunity, I was just in a wonderful session that Jeff Chasen and Dr. Banerjee did on autism spectrum disorder accommodations. Absolutely marvelous. If you were in there, you may find some of this a little repetitive because we're going to be talking about the same kinds of areas, because I'm going to talk about disability law in terms of threat to self. So students, specifically students who present a threat to themselves. So I apologize in advance if I do some kind of repetitive stuff for you. Okay. These are the general issues that I want to talk about. Students who threaten themselves, attempt to harm themselves, actually do harm themselves. The law in this area is not entirely settled. So what I am telling you is I'm guessing. You will be guessing. Your attorneys will be giving you good advice, and the way they'll give you good advice is to tell you to be reasonable. Reasonable is the magic bullet. Reasonable is the thing that gets us out of lawsuits and gets us through investigations. So if you act reasonably, you are going to be in better shape. If you act unreasonably, not surprisingly, there can be big problems. I've seen statistics saying that suicide is the third leading cause of death among college-age students, that this is an epidemic, that there are increasing numbers of students harming themselves and threatening to harm themselves on our campuses. What is your view of this? Can I see a show of hands of people who think it's increasing? That's almost everybody in the audience. And by the way, we are streaming this, so if during the presentation, if you would like to interrupt me and ask questions, I welcome your questions at any time. We'll also try to leave a little bit of time on the back end, but if you could raise your hand and we'll get a microphone to you. We've got somebody here who can bring you a microphone. Our goal in talking about these issues is not to rid ourselves of students who are a threat to themselves. That is not what any of us in this room want to do. We want to do the best thing for the university and the best thing for the student. Sometimes those things coincide, sometimes they do not. Obviously, I am a lawyer for an institution. My goal, in fact, my professional responsibility is to protect the institution, but I always want to try to do that in a way that also assists the student, especially a student in crisis. Sorry, I'm not used to doing this where I can't see the screen, so I keep turning around to see what I've just done. Sometimes we have, well, why are we going to talk about ADA? Why are we going to talk about disability law if we're talking about threat to self? Partially because threat to self has now become a buzzword in the ADA world, and we all understand that there are new rules about threat to self in the ADA universe. But the reason that we're going to be talking about ADA, the reason I wanted to present this introductory material on ADA is because of the part of the Disability Act that addresses perception of students, the university's perception of a student. And I believe that we can all agree that in most cases, the on-the-street diagnosis of a student who presents a threat to himself or herself is that the student has some sort of disability, has some sort of mental illness, emotional disability. Something is wrong if the student is harming himself or herself or presenting a threat to himself or herself. Who's going to hear about that? Well, it may be your faculty members. It may be people in your counseling center or your health center. It may very well be people who are in your police departments or student conduct or residence life. It can be a whole panoply of people on campus. And in most of our campuses, we have put together behavioral assessment teams. Can I see a show of hands of who has a behavioral assessment team or behavioral? Oh, wow, that's great. And I do think, and that, again, for the listening audience, that is virtually everybody in the room. And I think I'm from Virginia, so obviously the Virginia Tech tragedy was extremely, literally close to home for those of us in the Commonwealth. And I think everybody after that incident, both from a strategic standpoint and a practical standpoint, put together behavioral assessment teams or behavioral intervention teams or whatever you call them. We liked the idea of calling ours the BAT team, so that's what we've got on our campus. Those teams have been incredibly valuable in information sharing and in letting us all think strategically about the issue of a student who is in crisis. I am not an expert on BAT teams or BAIT teams or BIT teams or whatever you call them on your campus. There are people out there who are. I just have, I do serve on the BAT team on my campus, and it has been a learning experience for me as well. And the sharing of information has been a really valuable tool. The Rehabilitation Act is what we all started with. All of our campuses started with this back in the 70s. We're used to dealing with disability law. We're used to dealing with it in terms of either Section 504 or the Americans with Disabilities Act. 504 is all of us. The Americans with Disabilities Act is, Title II is for people who are in public institutions, as my institution is. But we've been used to this. One more question about BAT teams. How many of you have a Disability Services Office representative on your BAT team? Not quite as many. Let me suggest to you that it might be worth considering the possibility of adding your disability services folks, if you have them on campus, onto your BAT team. For those instances in which you have someone who is already registered, it can be very useful information to know that. Also, to have the expertise of that person on your campus to inform the deliberations of that body. It can be a very useful exercise to have that sort of discussion with the person who is best suited on your campus to address issues of accommodations and of disabilities for students. Disabilities Act, Americans with Disabilities Act, enacted in the 90s. This is going to be background for most of you, but again, Title II covers governmental entities like public institutions of higher ed. Title III arguably covers private institutions, but we're really going to focus more on 504 than on Title III. Title III is just not something that we deal with all that often. This is what it covers. This is all background, I think, for most of the people in this room. Actual mental or physical impairments, record of disability or regarded as having a disability. And remember what I said before, the public perception of your students who pose a threat to themselves will be that they are disabled. So you have regarded as cases starting with your discussion, either on the BAT team or on campus in general, of a student who has posed a threat to themselves. ADA requires non-discrimination, just like 504 has always done, and it requires reasonable accommodations, again, as 504 has. 504 has taken has followed ADA law since the 90s. But what has happened to ADA has been pretty dramatic in the last several years. We had lots of decisions coming out of the courts in the late 90s to the early 2000s. And these are some of the main ones. The Sutton case, which had to do with twin sisters who wanted to fly airplanes, and they applied for jobs and they were told that they couldn't because their uncorrected vision was really amazingly bad. I didn't know that 2200 vision was a common thing out there, but apparently it is. And so they were turned down for jobs and sued. The Murphy case had to do with a mechanic who wanted to work for UPS and couldn't pass his commercial driver's license test for the second time. He was actually, yes, he had high blood pressure. His blood pressure had gotten worse over the course of his employment. And the Kickenberg case, which was a truck driver for Albertsons, for the grocery chain Albertsons, who was actually blind in one eye and couldn't pass his DOT his DOT licensing exam. In all these cases, the courts said these people were not disabled. And that was sort of remarkable for those folks who had written the Americans with Disabilities Act, who thought that people who were blind in one eye or who had uncorrected vision that made them essentially blind or who had severe high blood pressure, life-threatening high blood pressure, were not disabled. But in each of these cases, the court said, well, their conditions are under control. They have mitigated. They have found ways to be not disabled, to function not as disabled individuals, but as just the same as all the rest of us. Because of cases like this, and the Toyota Motors case, by the way, the Williams case was carpal tunnel syndrome. It was a woman who worked on an assembly line who couldn't do the job anymore because her carpal tunnel had gotten so severe and so bad. And she was held not to, she did have a disability, no question she had a disability, but the court said that she couldn't perform one particular job, one very narrow job, but she could work. And working is the major life activity, not performing an assembly line job, putting a widget on a gadget, and so they threw her case out as well. So you get through all of these kinds of cases, and Congress said, wait, that's not at all what we had in mind for the ADA, and so they passed the ADA Amendments Act. And the ADA Amendments Act, the only act I know of that has the word act in its name twice, it's, who knows, overturned the cases that limited the interpretation and greatly broadened the scope of the ADA for all of us, not only for institutions of higher ed, but employers everywhere under Title I, Under Title III, it's any kind of public services, so it's huge implications for this case. I did hear an estimate that the number of people who now are covered by the ADAAA is half of the population of the United States. Now, I'll tell you why in a few minutes. Don't let me forget that. I want to come back to it because I think it's fascinating. Here's what physical or mental impairment definition looks like. Any mental or psychological disorder, intellectual, organic brain syndrome, emotional, mental illness. And you can see now why, if a student poses a threat to himself, he may be perceived as or regarded as disabled. And there's a new list of automatic impairments. I just listed 5 of them, 6 of them, 1, 2, 3, 5 of them up here. There's a list of 20-something of automatic disabilities where if you have documentation that you have this disability, you are automatically covered and no further inquiry is called for, according to the ADA. The significance of the change. In most cases, certainly all the cases that are on that list of 20-something disabilities, you do not need, and in fact the government tells you you should not make any further inquiry on whether or not there is a disability once you have that diagnosis. What you're supposed to do is assume the disability, which means assume there's a substantial limitation on a functional part of the person's life without any extensive analysis. That's not defined. I can't help you there. I don't know what an unextensive analysis looks like, but that's all you can do is not extensive. And then you move directly to the question of accommodations. Now, the question of accommodations is actually two-part. I didn't put it on here, but it is, first, are there accommodations that would work? And second, are those accommodations reasonable? It's two-part. First, is there anything that would work? Second, if there is something that would work, is it reasonable that the university, in this case, provide those accommodations? By the way, you can still ask for documentation. Remember, you have to figure out first if there is a disability. And although there are guidelines out there, and this is, Dr. Banerjee was talking about this in the previous session at some length, there are guidelines out there that talk about whether you should ask for medical documentation first, or you should just ask the person who is claiming a disability for their self-reported diagnosis. It is still legally acceptable to ask for documentation of a disability. I will give one caveat, and that is, in general, if the disability is obvious and it's visible, it's audible, the disability is something that is self-evident to the observer, casual observer, asking for documentation may get you into a relationship you don't want to be in with the person who says, I'm obviously disabled, why are you asking me for documentation? You can still require it, and I have one war story, and I promise I won't tell more war stories. I had a client who didn't ask for disability documentation of a gentleman who was in a wheelchair as a student at a university where I worked. The person was in the wheelchair, very long story, cut very short, lots of accommodations made for the individual over a 2-year period, and when we finally received the documentation, we found that he was in the wheelchair because he was schizophrenic and believed he needed to be in a wheelchair. He had no mobility impairment, but he thought that he did. And so what we should have been doing is addressing his schizophrenia and whether there were accommodations that would allow him to participate as a student for that. Instead, we were addressing things like, he said, I can't use my legs, I'm losing the use of my arms, I have nerve damage from a spider bite. It was very odd. It was a very odd case. And I only tell you that for this reason. The OCR, when it came to that campus and did an investigation based on his complaint, told the university that it had to continue every accommodation that it had done for the last 2 years because we regarded him as having those disabilities. Now, I think the law in that case has changed because the OCR will now tell you you need not, and ADAAA says you need not accommodate a disability that doesn't exist that you regarded the person as having. That's what the law says now. This was a long time ago, and we were stuck with providing accommodations to someone who did not need the accommodations we were providing. It was very odd. That's my only war story. Yes, and do you want to use the microphone?
I gotta be so I just want to stop you here because we have a large number of students who do have some sort of disability but can't afford the diagnosis or get the actual information that our counselor for disability needs in order to give them accommodations. And that's a big problem because it costs, I think, something like $500 for them to go through a process to get the paperwork they need. And I'm wondering, with all the students that have all of these new found disabilities that are coming out, what are they doing to assist them financially so that they can be diagnosed? And if anybody, I'm in New Jersey, so it's very hard for a lot of students are walking around without being diagnosed because they can't afford to get the actual paperwork they need to give to the counselor.
Okay, for the audience that's listening remotely, the question is, if a student cannot afford to get the medical diagnosis that they need in order to get the accommodation they require in order to participate fully in the institution, what can the institution do? Or how can that student get help? I do not have, I'm not a disability services provider. I mean, I don't work in that arena, but it's my understanding that most states, if not all, have rehabilitation services offices at the state level, and that students who are unable to afford getting diagnoses through medical providers can go to rehabilitation services offices. Does anybody have information about this that's out there that can give us some help? Yes.
The one thing that we do on our campus is our counseling psychological services office offers the testing at a very reduced rate. In Indianapolis, $400 is what our counseling centers charge, and that's a fraction of what it would cost to go within the city to get it done. So we've done it through that way, using our counseling psychological services for the testing.
Okay, so we've got one suggestion that some campuses also have services on campus where they will provide diagnoses and at a very reduced cost to the students of that university. So that's another possibility. You can check with those kinds of resources. Okay, let's see. Where am I? Okay, this is a definition of what substantially limits means. Remember, it's a disability is a condition that substantially limits a major life activity. When I said that half of all of us are covered by ADAAA, well, if the definition is someone who is less able than an average person to perform a major life activity, yeah, less than half. I mean, it's the average is half, right? So 50% of the people are less than able. It's a very odd circumstance, and I don't think that this is literally true. I heard a commentator saying it. Remember, this has to be on the basis of a documented medical condition or psychological condition, or there has to be something medically going on in order for you to qualify under ADAAA. The ameliorative effects of an accommodation. Medications are the ones that are most commonly talked about, are not to be considered when you are determining whether the person has a disability. So, if I am on high blood pressure medication, I am to be evaluated to figure out if I have a disability in my unmedicated state. Now, I know some people in their unmedicated states can't survive. It's another difficulty, I think, for all of us within the practice area that we are trying to determine what an unmedicated state would look like for our students. Most of our students who have disabilities that require medication take their medications. I know that there are instances where that doesn't happen, and those can bring some very challenging situations to us. Remember, it's also things like devices and any kind of coping mechanism. In the Kirkenberg case that I talked about earlier with the gentleman who had vision only in one eye, he had developed coping mechanisms where he had learned to assess depth perception with only one eye. He had monocular vision and had managed to figure out ways to have essentially the same kind of cues that the rest of us do automatically. He had trained himself to do. So he was actually able to get a waiver from DCL, but even for his DCL, his commercial CDL, commercial driver's license, and still the employer wouldn't hire him. So any of those things, any coping mechanism, any device, any medical, any kind of ameliorative effects of any kind of accommodation that the person is doing for himself or herself or provided by the university don't count when you're trying to decide, does the person have a disability? These are major life activities. It's been greatly expanded, not terribly interesting for our discussion. And here's the slide on regarded as. Anyone who is regarded as disabled is covered by the full force and effect of the law, with one exception, and that is that middle one: no duty to provide a reasonable accommodation if they don't actually have the disability you think they have. If you have an intent to discriminate against an individual, against the student, let's say, you're going to lose a lawsuit. If the student brings any kind of lawsuit or charge against you and they can show that you have treated them differently because of their either perceived or real disability, you will lose. That was one of the things that the courts, even the lawsuits that were out there, if there was ever any evidence of animus against the individual who brought the lawsuit, they were winning even before the ADAAA was passed. And as I was saying before, if you have a student who has exhibited self-harm, either intention or attempts, or has actually succeeded, the public perception will be that they have a mental illness or an emotional illness, that they have a disability that's covered by the ADA. Now, in order to be protected by the ADA, the student also has to be a qualified individual, and the OCR gives us a definition of this. OCR is up until very recently, and I hope all of you heard Peter Lake's excellent opening remarks, up until very recently, OCR has led all of us in interpreting what the ADA and the ADAAA have said. Department of Justice has stepped in recently and is taking a much more active role in interpretation of the ADA, and that may change some of what goes forward. But this is where the qualified individual is where we finally get to the question of direct threat. I apologize it's taken me so long to get here, but you need the kind of background to get to what a direct threat analysis looks like. The OCR is given the regulatory authority to enforce Section 504 and Title II, but it's given that authority through Department of Justice. And this has to do with the interpretation of direct threat. So the previous interpretation was that a direct threat was a direct threat to either the individual or other people. All these cases, the Woodbury University was a 504 case. It had to do with a suicidal student who had attempted suicide over Thanksgiving break when she stayed in her residence life facility over break when everybody else went home. So she was not allowed to stay there over Christmas break. And she sued and said, "You have regarded me as disabled, and you have said that I am going to harm myself. That's not self-evident. I'm not going to harm myself, and you have discriminated against me because you perceive me as being a threat to myself." The OCR wrote a letter to Woodbury University, where she was a student, and said it's a reasonable expectation that she will attempt to harm herself if you put her back in that exact situation that she was in last time she tried to do it. So it's perfectly okay for you to remove her from the dormitory setting over the Christmas break. That was back in 2001. We're considerably past that now. The Knapp case was a student athlete who had a heart defect and was told he could not play basketball for the intramural team, not intramural, the intercollegiate team. And the Escobar case was the Chevron versus Escobar was actually an employment case, and it was decided under Title I of the ADA, saying that Title I does not say anything about threat to self. Each of the titles has its own definition of how you make your determination as to what counts for a qualified individual. It doesn't say anything about threat to self, but EEOC had interpreted Title I as including threat to self. EEOC was in this lawsuit given the authority by the court to make that determination to add threat to self as another category of an individual who is not qualified under the employment law. Department of Justice in 2010 came out with new regulations saying that, well, actually they didn't say much of anything. They omitted words. The former wording had been threat to self or others. The words self or were removed from the regulations under Title II, and that's where we all have landed in an era now where threat to self is no longer a safe harbor. If we are considering the possibility of, for example, removing a student from our campus who is a threat to himself or herself. They became effective in 2011, and we don't have we don't have case law since then. What we have instead is a lot of analysis. And most of my colleagues at other institutions have rather carefully read through all of their policies, all of their procedures and protocols dealing with either involuntary withdrawals or removals of students, their BAT team protocols, their any kind of student conduct codes that deal with a student who is a threat to self, and they have removed the language or modified it significantly in order to come into compliance with DOJ regulations. So one thing I would urge you is when you go back to your campuses, take a look at your involuntary withdrawal or removal rules, at your student codes of conduct, if you have BAT team protocols and rules and procedures. My institution actually doesn't. We do things completely ad hoc. On every BAT situation is handled as a new day, and we try to tailor everything for the individual student situation. But if you have them, I strongly suggest that you go back and take a look at them and see what your policies say right now. The Spring Arbor decision letter was by OCR was sort of a turning point for all of us, because that's the first time the OCR, anticipating what Department of Justice final regs would say, came out indicating that threat to self was not part of the analysis in the removal of a student. So that was their first sort of abandonment of the threat to self defense. Oh, here's the code of conduct. Your codes of conduct need to apply to all students, obviously, and they need to apply equally, not just to students with disabilities. The disruption of attendance, participation, and activities will be in all of your codes of conduct. I virtually guarantee it. The question becomes whether a disruption of either other students or of the staff of the university, the job functions of employees, whether those things can be maintained in your policies, even if threat to self comes out. Now, disruption is one of those funny words. It's one of those judgment words. It's one of those things where you have to make a decision as to how bad the disruption gets before a student is removed from the university or from the activity. For example, I have heard some commentators having the question of an intentional threat to self as opposed to a reckless threat to self. Here's the example that I heard. We all have students who are reckless and stupid, and I'm using those as terms of art. We have students who do things like we had one on our campus. We had a flood of a little stream that goes through campus. He got a kayak and put the kayak in the little stream that normally runs about 2 feet deep and was running about 7 feet deep, and got himself stuck in a culvert. Luckily, he survived, but just barely. And it took fire department and police and all kinds of people to rescue him. That's reckless and stupid, and we would all like to slap him up the backside of the head. But he was not intentionally hurting himself. He did something crazy, and that's what hurt him. If that student is treated the same as a student who intentionally tries to harm himself or herself, I wonder, and this was actually this is a discussion before the threat to self change in the Department of Justice regulations, but I wondered then if we should not have a discussion about reckless, stupid behavior as opposed to intentionally self-harming behavior, and if those two things get treated the same. Yes? Oh, microphone, yes.
We have sort of a stalemate happening at our university. We've got a student who is very severely diabetic. Mm-hmm. He's also autistic, and he often forgets to regulate his diabetes. We've got EMSA coming maybe once a month to get his insulin. When are we at a point where we can say, okay, this has got to be regulated, because his defense for not regulating is his autism. And so we're kind of at a loss as to where we can go with this young man.
Okay, so as I understand it, what you've got is someone who has multiple issues, medical issues, which is not uncommon, right? Is everybody experiencing more of that? Yeah, I'm seeing a lot of head nods. Medical and mental disability as well, and it's the combination of those two that seems to be posing a threat to this student's well-being. The student's not taking his meds, so he's not regulating his diabetes, so he is becoming ill, and you're dealing with the illness, and your question is, when do we step in and do something?
When does the defense of his being autistic stop? When is the limit reached where we can say, okay, this is out of hand?
Okay, I think I understand. The university has multiple challenges in dealing with a student who has multiple disabilities. All of the disabilities are valid. All must be accommodated if it is possible and reasonable. Remember, 2 parts to the accommodation question. Is it possible to accommodate them, and is that accommodation reasonable? Now, one thing that that Jeff Chasen and Dr. Banerjee talked about in the previous session was there are circumstances where no accommodation will work. The case that Jeff Chafin talked about that he actually defended up here in Vermont was a decision by the University of Vermont that a medical student who lied about his credentials and his training could not be accommodated because one of the facets of being a doctor, of being trained through the medical profession, is that you have to behave honestly. And he said, I'm not honest because I have an emotional disability. So it was essentially excusing his inability to be honest. In the same way, I think the situation you described, where the student said, I cannot take my meds because I have a mental disability that won't allow me to remember to take my meds. We need not say to that student, well, then you're excused from taking your meds. It's okay if you don't take your meds and you become extremely ill from your diabetes. It's not up to us to say, you must take your meds, but if he doesn't take his meds and he becomes too ill to continue because of his diabetes, then we have actions that I think we can take to help that student. And please understand, I'm not trying to say that it's an assistance to the student to remain at the university. We need to assist the student in both in being as healthy as the student can be, but not necessarily on our campus. I don't know if that was at all clear. I feel like I was muddled in my discussion of that. We have to make accommodations if they're possible. If they're not possible, we don't have to make them. If they're possible but they're not reasonable, we don't have to make them. For example, that student could have said, I need somebody to remind me every morning to take my diabetes medicine. That's not a huge surprise. She's saying that's what the student has asked for as an accommodation. That's a personal responsibility of that student to take their medication. It is, in my opinion, it would not be reasonable for the university to have a personal assistant to that student to remind the student to take his meds every morning. And believe me, we've had parents who have requested, you can't make this stuff up if you try, who have requested that a faculty member call a student every morning at 8 to say, please come to class. Because my student has sleep apnea and will oversleep their alarm. And so I need someone to make that phone call every morning. My question was, are your fingers broken? You make the phone call. Come on, Mom. So I believe that personal assistance, the ADA has always said, personal assistance devices, coping mechanisms, things like that, are not required to be provided by the university. But the request for a personal assistance device can be rejected, and the university can say no to that. Did you have something else? No? Okay. Okay. All right, let's see.
Realize it's not my school, so I have no idea what the backstory is, but I'm not in the disability side, I'm on the BIT team side.
Okay.
So if I got this case, I would be saying, all right, so we have this student passing out on campus once a month and all the emergency personnel are involved. This is disruptive to the other students on our campus and to our staff and all those things. So And from what I think I'm hearing you say, we don't have to provide, it is not reasonable for us to remind this student every day to take his medication. So therefore, we can do an involuntary we can convince this student that it's best for them to leave and do an involuntary withdrawal.
That's really interesting, because think of the way you just said that. First, you said we can do an involuntary, we can convince this student that it's in their best interest.
Right, I realize that's a
Absolutely.
semantic thing,
You
but
can, if you can say to a student, and I'm being very, very serious here, if you can say to a student, it is not in your best interest to remain on this campus if you cannot take your medication and remain healthy. You need to be somewhere where there can be someone for you who will remind you every morning to take your diabetes medicine. It's not here. We cannot and will not, it's not reasonable for us to do that. So we need for you to think about your self-care and to think about what is best for you. And we think it is best for you to be in another setting other than in our residence hall, where no one will be saying to you every morning, did you take your meds? Did you wake up in time for your class? Did you do whatever it is that you have to do to successfully be a student at this institution? If you can talk the student into going to a place where they are better served, great. The question I have still, and this is an open question, as I said at the beginning, I am guessing. I have a question in my mind whether the Department of Justice and the OCR will now allow us to say, it is in your best interest, therefore we are kicking you out of this institution. If it is disruptive to have an ambulance called once a month to pick up the student who has just collapsed in their classroom, disrupted the class, or collapsed in the cafeteria, disrupted the dining services, or as walking down the sidewalk on campus and the police have to be called and it's cordoned off. If it's disruptive, how disruptive does it have to be before we can say the disruption of the campus is our reason for removing this student? Once a month? I don't know. Once a week? Well, that gets closer. What if it's every day? Then does your university's paralysis, its inability to function as a university, become the reason that you are insisting, not suggesting, but insisting that the student leave your university and go somewhere else where they can have a healthy, reasonable opportunity to function? I don't know the answer to that one. My suggestion is that you look at your policies and you very carefully, in your BAT team or BIT team or BAIT team, talk about when have we gotten to the point that it's not just inconvenient, it's not just disruptive in the kind of generic, oh gee, that was one incident that really disrupted things for an hour. But now it's to the point where this professor can't hold his or her class because every single time the student comes in, goes into a diabetic coma, and the police are called, and the ambulance has to come, and the class is dismissed.
so where we're left with is convince the student to go.
That's
excellent choice. Or wait until it is disruptive enough that it can become a conduct issue, and student conduct can say this has risen to become so disruptive to the community that student conduct will remove the student.
I think that's exactly right.
Okay.
And remember, it has to be non-discriminatory.
Right.
So you'd have to treat a student who was a jerk and came into that faculty member's class and disrupted the class every Thursday. Not because they were off their meds, because every Thursday they turned into a jerk, like a full moon, and they just and start disruptive behavior. And if you treat them the same way, I think you've got a defense, even under the Department of Justice's new regs. Regardless of his autism diagnosis, yes, because the autism's not causing the behavior. The autism's causing him not to take his meds. Not taking his meds is what's causing the disruption. Yes? Oh. It's caught her eye.
But if his autism is in fact, if he is disruptive and he's saying, I'm disruptive, but it's because of my autism, which probably doesn't make sense, but for the sake of this example, but he is so disruptive, it sort of, my understanding would be it doesn't matter that he has a disability, I can still run it through conduct.
Absolutely.
Okay.
Yes. Yeah, in that particular instance, the only thing the autism was doing was causing him not to take his meds. But if there's, under the ADA, under any of the regs, under anything, your student conduct codes, if they are applied equally and non-discriminatorily to all students, they apply to a student who says, the reason I am acting in this particular way is because of my disability. Now, again, this great session that we just left with Jeff Chasen and Dr. Banerjee, they urged, and I think it's a wonderful suggestion, they urged a whole person sort of review. No cookie cutter approach is going to be preferred by the Office of Civil Rights, the Department of Justice, no state agency or federal agency, and don't forget about state law. I think I forgot to mention it earlier, but you also have state laws that deal with disability issues. No legal entity is going to be pleased if you say, oh, diabetes, here are the 4 accommodations that we do for diabetic patients. You don't fit on one of those, so you don't get one. You don't get what you asked for. You never want to use a cookie cutter approach for accommodations. You never want to look at any disability as being exactly the same as every other person with that disability. We're all human beings. We have different metabolisms. We have different emotional and mental abilities and disabilities, and none of these conditions are exactly the same in one individual as in the next individual. You have to look at them individually. You have to enter a dialogue with a person about an accommodation if you find that there is a disability. There's a question in the back. If you want to, we'll bring the mic to you.
For the student in that situation that eventually the light bulb goes on and says, you know, you're right, I'm not doing well, I'm going to take your advice and I'm leaving the institution, and takes a voluntary withdrawal, medical withdrawal, whatever you want to call it. What's your caution in regard to setting conditions then in that circumstance for the student to come back? The conduct process, you can set conditions, you can do all of that, but we're still dealing with the same situation, right, where if the disruption was there, we might remove them, but we're giving them the option to leave. What is your caution in regard to those conditions?
Okay, for people who are coming back after a medical withdrawal, either a voluntary or an involuntary medical withdrawal, at my institution, we have frequently, not always, frequently asked for a doctor's release. This student is now capable of complying with their medical regimen. This student is now capable of self-care, capable of participating fully in the educational process. Our medical withdrawals come for a million different things, from a broken leg to an emotional meltdown to it could be, the whole spectrum of possibilities.
But if we don't, in an ordinary medical withdrawal, at my institution, when a student leaves, require them to produce any medical documents?
We do.
Yeah.
Any medical withdrawal, we ask for medical documentation when they come back. So if emotional, mental, medical withdrawal is the reason for them leaving, we ask for it, whether we do it, impose it on them, or they do it voluntarily. Now, we have students who just disappear for medical reasons. I mean, they're just not there. It's Wednesday, where's Johnny? Well, he's not here. We don't know why he's gone. In those cases, we don't condition their return on any kind of medical documentation because we don't know that there's a medical crisis going on. I don't know that that helped.
Well, I'm thinking of the Spring Arbor case and where they did require that documentation where they would not have on another student that left. And if we go the route of allowing a student just to leave, they choose the good choice, then, and it's not a conduct issue, I guess that's my question, you know, do we then still have the opportunity to set those conditions? So.
Yeah, I think you put your finger exactly on the difference in Spring Arbor. The thing that Spring Arbor, the crux of that case, in my mind, was they were treating that student differently than other students. And treating a student differently on the basis of a disability, remember when I said if you can show a discriminatory animus, you're gonna lose? I think that's what the Spring Arbor case was actually about, that they were saying, you're going to be punished for being ill, and we're going to make you jump through hoops that we would not make other students jump through. So I think you're exactly right that differential treatment. Now, I don't know that my university is doing the right thing by asking every student who leaves for a medical reason to provide medical documentation and no other students to provide them. I don't know that that's true, but frankly, there's a logic in my view to saying to a student who says, I must leave, I'm ill, to say, are you well when they come back? It's not, in my mind, a discrimination issue. OCR could very definitely disagree with me on this. Yes?
Yeah, I just have a question kind of stemming off from the conversation up here. So suppose you have a student who has an issue not taking his medication and passes out, maybe not every day, but maybe twice a month or whatever. And so I sit this kid down and I said, listen, you know, is this a good place for you? Should you be somewhere? What if the student says, I don't want to leave. I like it here. I don't want to go. Can you make me go? No, I can't make you go. So I mean, if you can't, because you have to like make something into a conduct issue. So what if you really can't make it into a conduct issue, but you have a kid that has an issue, but says, I don't want to go?
I think you're describing what everybody in this room has seen at least once, and maybe once a semester. Yeah, I think that does happen a lot. And actually, if I can complicate it just slightly, I've also seen the situation where the parents have said, oh, no, Johnny, don't come home. You're much better off at the university, because we don't want to wake you up and tell you to take your meds either. And there's a question way back there.
Tied to that, if you can have a student who you strongly suspect has an undiagnosed mental illness, is this something you ask in the community from time to time? Sorry. He's having difficulties in school. Are you suggesting that I bring him up to a conduct review board?
No.
Okay.
Here's what I'm suggesting. The question was if you have somebody that you suspect may have a mental illness, but because their conduct is becoming disruptive, but it has not breached any code of conduct provision yet, right?
Yes and no. I would say I've wrestled with him for quite a long time on this.
Okay.
And I guess the thing is, I don't have any means to get him diagnosed.
No.
Okay.
Well, okay. If you're asking, should I bring someone up on a code of conduct charge who has violated the code of conduct, even if I suspect that they may have a mental illness, yes, bring them up on a code of conduct charge. If you have a diagnosis of a mental illness and the student says, I'm violating the code of conduct because I have a mental illness, do you have to excuse that? No.
One step further, if I have this conduct review, I can have stipulations. Can I have a stipulation of some sort of medical attention?
If you don't have a diagnosis, I think that would be really bad idea. But if you have a medical diagnosis and the student is going to withdraw from the institution, not be kicked out for conduct, but withdraw from the institution, this student is probably in front of your behavioral team. because now they have risen to the attention of the people on campus, the student conduct folks, maybe the disability services office, maybe the police, that there's a group of people who are seeing a student in crisis, and the conduct people or somebody may bring them to the behavioral assessment team, and everybody gets together and starts talking about them. And then the dean of students may say, I think this student is really not caring for himself or herself. I think that they're not coping with the institution well, and I think I need to have a conversation with that student and talk about whether this is the best place for them or they need to voluntarily withdraw and go elsewhere. All of those are strategies that we all use, and if they work, great. It's when they don't work. And when they don't work, then we are forced into the question of, is it so disruptive to have the student remain, or is the student's behavior, has it crossed that line into a student conduct violation? And if it's done one of those two things, then I think we've got a mechanism. Yes.
I'm from the University of Virginia, right down the road from you, so we do the same kinds of things you do. One thing we have for our judicial processes, both honor and conduct, is a psychological process that a student can appeal to go through, which doesn't let them off the hook, but it does involve mental health professionals who make a determination as to whether or not the conduct was associated with that mental health condition, which allows them to impose specific requirements in terms of care, in terms of returning to the institution, things of that nature. So not any student can go through that process, but any student can ask to go through that process and have a mental health professional determine whether or not they should.
So you have somebody on your campus who diagnoses or evaluates a student who asks to go through a specific procedure and if they go through that procedure and the diagnosis is, yes, they did this conduct violation because of a specific emotional or mental, or I guess those would be the only two possibilities, because of that particular impairment, then what happens?
Well, they go through a hearing process, and they have a mental health advocate of their own. Typically, they're a treating clinician or someone who's familiar with their case, and then a couple of mental health professionals who are not involved in the situation, who are objective persons who don't have specific involvement, but who make a determination as to whether or not that was a contributing mental disorder, a CMD process is what we call it. And then the penalty is going to be slightly different than it would be in a traditional judicial process, in that one can impose structures in terms of care, in terms of behavioral management, whatever the mental health professionals determine to be appropriate.
That's a really interesting approach. I've not heard that before.
It works really, really well, because we certainly don't want to run someone through a traditional conduct process who has a disorder of some kind. It doesn't address the issue of whether or not, if they haven't acknowledged or perceived that they have one, it doesn't address that, because you can't put someone in that process
Right.
without their wanting to do it, but you can certainly remind them that that process exists, which sometimes is enough of a trigger for them to seek that as an outlet.
Do you have concerns that by asking the student, what I'm thinking of is since ADA and OCR and everybody has said you can't use a disability as an excuse for violating a conduct code, do you have any concerns that you may be conflating the two and confusing the issue and saying you're only using it for the penalty phase?
No, it's for the evaluation of whether or not the act occurred and whether or not there's a contributing mental disorder that affected it. A student is still found guilty through that process if it is believed that they did in fact commit the conduct violation. It simply allows us a different route for managing that and recognizing that there was a disorder that needed to be attended to. So it's not as though they're off the hook. It just recognizes the context more effectively.
Okay, that's interesting. There's another one back there.
Well, it's an interesting approach. The one thing I heard there was, though, that the students self-identified that they had a medical issue that might have contributed to the problem. I would never want, and general counsel for a university, want us to ask that question, because then you immediately get yourself into the problem of regarding the student as disabled. So you address the conduct, you don't address the cause. I think that's an interesting approach, but I don't think most institutions are prepared to go that far. If the student wants to raise as an issue, I go back to your initial response, which was that neither OCR nor the Department of Justice have ever excused misconduct on the basis of a disability. So you don't need to have an analysis of what contributed to it. They're held to the same standard of care that anybody else is held to.
Yep, that's how my institution does it too, so. Let me go to one more. Okay. Yes.
I don't know if anybody else has encountered this situation, but if you invoke your code of conduct and you hold a hearing and the student declines or resists participation because of their disability, because it happens to be an emotional anxiety-related disorder, how would you suggest we approach that? Because the hearing can't even take place that would give them the due process that they have to have in terms of student conduct, but they refuse to participate, claiming that the disability impacts that they can't possibly, that will traumatize them further, and that will exacerbate their position.
Yeah, I have faced this before. We have been generous in postponing hearings. We have allowed students to have a person there as not an advocate in terms of speaking on behalf of the student, but to be there with the student, emotional support person with them. We've scheduled them on days when the student didn't have classes, so there was not the added stress of a class, and so we've tried to accommodate in those ways a student who says the process itself will stress me too much. My disability will not allow me to go through a regular process. We did draw the line at a student who said that she wanted to, I can't remember exactly what her request was. She said something about wanting to, oh, I know what it was. Instead of having a hearing panel, she wanted to meet with just one person. And we said, yes, you can meet with just one person, but then the panel will decide. And you could meet with them individually if you want to meet one-on-one with the three people. You could do it that way. But she said, well, no, I just want it to be heard by one person. And we said, I'm sorry, that's not part of our process, is that we have a group of people who do an analysis. So it's not just a single person's judgment. So we've drawn lines. We've granted some accommodations in those and not granted others. We've not allowed a student to simply not go through the process. Well, what we've told them is, if you don't go through the process, you're probably going to be found responsible. So you can opt out of the process, but understand what the consequences are for doing that. Okay, one thing I did want to make a point about, again, you're not required to provide accommodations if the person is merely regarded as, so if there is no diagnosis, you don't have to provide any accommodations for that individual, and you get to decide what is a reasonable accommodation. That is within the purview of the institution. There's also a risk analysis, I think, to be performed here, and that is, if there is a dangerous condition. Remember the case with the student who had attempted suicide over Thanksgiving and then wasn't allowed to live in the dorm over Christmas. That student wasn't kicked out of the university. The remedy in that case was, don't let the student stay in the dorm over the holiday break. So if you can look at what the risk is it really the risk of being on campus and being a student, or is it the risk of being in a particular setting? And if you can accommodate that and not the larger question, I truly think that you're going to be okay making a modification of that sort. Threat to others, of course, still a perfectly valid defense under everybody's analysis, and I suggest in my paper, by the way, that disruption, collateral damage, emotional distress to your other students is probably not going to be enough to get you past a DOJ challenge or an OCR challenge to your policy or your practice. But, and so not a threat to other students' ability to participate unless it shuts you down, unless it shuts down a class, an activity. They can no longer effectively do the job of the institution to educate students and to provide services. Then I think you might have an argument, even without the standard analysis of threat to self. You might be able to continue to say that's a threat to the institution's ability to operate. If anybody has any questions, I'd be happy to. We just got a couple of seconds, I think, left.
We're currently debating within our state what is our ethical or legal obligation to notify. If a student indicates to us, we remove them for a direct threat to others, that they are transferring to another institution. Our opportunity to notify them or to notify law enforcement if we don't know where that student is going.
Okay, if a student is transferring to another institution, you can talk to that other institution about your concerns because FERPA allows you to. There's a specific part of FERPA, and I don't think Steve is here anymore, but our FERPA expert was here earlier and would be happy to answer that question, I feel certain. FERPA allows you to talk to any institution your student is transferring to about that student's education record, period. Well, your education record for that student includes all of the issues that we've been discussing. Talking to law enforcement is a little different. I would suggest this, and if there are law enforcement people here and I'm stepping on toes, please, I'm sorry, I don't mean to, but have your police talk to their police. Don't do it from the Student Services Office, don't do it from the legal office. Police to police is the way to talk. And in that instance, I am less sure that FERPA is okay. But Steve, again, would know that answer as well. I'll just repeat it. It's okay. Go ahead.
If I heard correctly, you mentioned earlier that half the population is disabled over the definition. And you want to be reminded of that?
Oh, yeah, that was the slide that I had about saying if you are less able than the average citizen to perform a function, you are by definition disabled. Well, I think that's not true, but I heard a commentator say that means that half the people in the United States are covered by the ADA because half the people, by definition, are less able than the average person to perform a function. But you have to have a disability in there somewhere. You have to have a medical condition in there somewhere. Thank you very much.